So, Mark, the UK government has just published the National Security Investment Bill, which sets out the UK's first standalone regime to control M&A transactions and investments in the UK on the grounds of national security. Can you tell us a little bit more about the bill, please?
Yes, absolutely. It's a pleasure to do so. It really is a night and day change that's been announced here. So just to set the scene, at the moment, we have approximately only 5 or so deals every year, which are called in under some rather Byzantine processes for national security review, which form part of the wider competition or merger control rules. So it's very unusual for national security to be picked up in deals. As a result of the new National Security and Investment Bill, we are moving to a brand new regime where government scrutiny, not CMA competition regulator scrutiny, but direct government scrutiny and potentially intervention will apply to a vast range of transactions, investments on national security grounds. In a sense, it shouldn't come as too much as a surprise. It's been heavily trailed for a number of years, and actually there are similar foreign investment regimes in a number of leading jurisdictions, including Australia, the USA, Germany, and a number of others. But it does feel like the makings of a very big change, because it's going to bring in mandatory notification of deals across 17 very widely defined sectors, from energy to telecoms to AI to defense and others. And if those deals are not notified, and if clearance is not obtained in advance, those deals are void, and there are civil significant fines and criminal offences that may be committed if those deals are not pre-notified and pre-cleared by the government. So that is a real game changer. The government actually, so I've mentioned that at the moment we only have 5 national security deals approximately a year that get scrutinised. By the government's own numbers, they're anticipating over 1,800 filings under this new regime, which will be initially screened. And then potentially of those, just under 100 would be subject to the full call-in and full investigation, at which point the government would investigate in some detail and consider whether the national security implications required the deal to be either completely aborted or in part modified. The initial screening is meant to be a strictly time-limited 30-day process, and then it will only be that relatively small category of investigations, which will be a longer call-in period. But even that 30-day period is a big change from what parties will be used to. And just to emphasise further, this measure, if it was brought in as per the current bill, will apply not only to transactions involving foreign buyers, but also UK to UK businesses as well. So the net is being cast very wide in terms of deals that will need to be notified and at least formally part of the original screening. So from a regime-wide perspective, it is a real game changer. But from your perspective, Ken, thinking about M&A activity in the tech space, but specifically, do you think there are going to be particular impacts there and particular concerns?
Well, clearly, I mean, it's going to be quite a potentially very big difference from what we have now. I mean, we've always been a jurisdiction that's been relatively free from regulations of this nature. We've only really had the merger control regime and clearances in certain particular regulated areas, such as financial services, that we've often come across on M&A transactions to date. And I think the tech space is clearly a key driver and focus for this new legislation, as well as domestic investors and buyers. You know, overseas investment in the space has been widespread over the past 10 years or so, and an exit route for tech companies is very often a US buyer or other overseas buyer. In the past, you know, China was very prevalent, perhaps less so in this year's. I mean, for something in the markets right now, just look at the situation with Arm as a particular transaction to focus on, that being passed between China and the US, but there's many other examples. So although the legislation applies to both domestic and overseas, I think it's particularly in this space where overseas investment is so key, it's going to have an effect. And of the 17 identified sectors in the bill, there are some of those that we see very, very commonly here at OC. So I'm thinking in particular AI and data infrastructure, but also a number of others such as computing hardware, autonomous technologies, secure identification, and a number of the other forward-looking technologies, such as quantum computing. We're really seeing investors having a particular focus on in recent years in transactions. So what's the effect going to be? Well, I think in the first instance, we're going to look at, some more uncertainty. It's a word we've all become used to over the past 12 months or so, but this is only just something else that's going to create uncertainty. A key initial consideration for acquirers at the outset of a transaction is deal certainty. And this, whether a voluntary or mandatory notification needs to be made, will be something that at the very outset of processes, people will be looking at. And as you say, the consequences are potentially very severe. No one wants a transaction to then be deemed void on the deal certainty basis, and the sanctions of being, up to 10% of global turnover, or the greater of 10%, 5% of global turnover, or £10 million, and also criminal sanctions for some of the larger tech players. That could be very, very substantial sums of money. So that is something that they will be looking at in these transactions. And there's very, very low thresholds for the triggers as to when a notification needs to be made. So I think generally here we're talking about the 100%, M&A transactions or asset deals where the whole of an entity is bought. But the regulations can catch investments of 20% or higher, or if there's undue influence being sought, perhaps even at 15%. So then you're falling into the world of venture capital investment, which is an absolute lifeblood for the UK tech industry from both domestic and overseas investors. So I think until market practice develops, I think we're going to see an increasing number of voluntary applications, particularly in the case where there's overseas buyers, but across the piece. I think right at the outset, the informal inquiry process, I suspect, is going to be very busy as people try to figure out their plans over the next few months. I also think wider than the identified sectors, we may see other transactions, considering whether they might fall into the ambit of this, given the sort of ubiquitous nature of tech these days, and things aren't always as black and white as something neatly falling into one sector or another. And then in terms of deal mechanics, I think we're going to see more split exchanging completions and longer deal processes resulting from this, because people will want to sign to lock in the deal before they make the filing, with a certainty if the filing comes through that then they can then go ahead and execute the deal. That said, I don't think what has been proposed is quite as widespread as some of the other jurisdictions you mentioned. So in Australia, for example, absolutely every M&A transaction has to be notified. That's not what we're doing here. And given the UK's strength in innovative technologies, provided this is implemented correctly, I don't see this necessarily as a deterrent for M&A activity. As a comparison, looking at the fintech space, where an FCA clearance has been pretty much needed on every single transaction over the last few years, I don't think that's stopped deals. So I don't see it necessarily stopping transactions. And in terms of the UK government's approach, it'd be interesting to see how interventionist they want to be. Generally, that's not been their approach. So I think we'll have to see how it develops. But they're already making noises about it's only going to be a small number of transactions that will actually be called in. But then again, that's not going to affect whether you make a voluntary notification or not. And we've also got Brexit on the horizon. We can't avoid that. There is Brexit out there. So, it's just definitely another factor to look at in, when an overseas investor looks at the UK. But, if the asset is right, it's going to be a hoop that people are going to jump through. So, bringing it round, Mark, given, OC's tech specialism and, our sector focus, I think it's fair to say we have a lot of experience to help clients in this space.
Yes, absolutely. And it's the need to do additional filings, of course, particularly when we have an intuitive feel that they're not problematic from a substantive perspective. The deals, in our view and in the client's view, clearly don't raise national security concerns of any kind. I appreciate that many clients are going to find that frustrating, and as you indicated, there could be some additional time and cost associated with that. I think in terms of Osborne Clarke's role, we're vastly experienced in managing multiple filings, whether that's cross-jurisdiction or filings with various regulators, and making sure that we, so far as it is practically possible, that we keep deal timelines on track, that we give clear, advanced, predictable forewarning of any delays, and that we're able to use our existing contacts with regulators and with government to make sure that deals proceed as necessary and as has been envisaged. I mean, just echoing the point that you rightly made, I think our view would be that clearly in these early months there are going to be some teething problems. I think it's invariably going to be the case, but we're also confident that the government's overarching objective here is to grow international trade, and is for foreign investment to continue to develop and grow, and for the UK to continue to have a leading position in Europe as a home for foreign investors. So we would hope and expect that will remain the case, and that although this does add a degree of formality, hopefully it will be a relatively small and hopefully predictable piece of the transaction journey for most clients.
Certainly hope so. Well, thank you very much, Mark. So, clearly this is a new and developing area, and we're going to be producing more guidance and commentary as this progresses. So watch this space. At Osborne Clarke, we're a very active player in the international M&A market, particularly the mid-market. And we have market leading, as a bit of a plug, market leading specialists in areas such as AI and data that helps us to really understand these businesses, of which the focus is very much on of this legislation. So we'll be hopefully bringing you real world examples at the coalface, so to speak, of this as it develops. But to wrap up, thank you for your time. I hope you have enjoyed this discussion. Please do visit our website for more insights on this and tech M&A in general. And thank you very much for your time today.
Thank you.